Excellency Muhammad Ka, Professor Dominguez Redondo, Dr. Eric Tistone, and Dr. Mark Lehman. My name is Ali Furat, and I am the president of the International Association for Human Rights Advocacy in Geneva. Since its creation in 2017, our organization has been dedicated to supporting victims through strategic litigation with a particular focus on Turkey. It's a real pleasure and also a point of pride to welcome you today to our third webinar since launching this series last year. Our first discussion explored the practical impact of the special procedures, and we had the honor of hosting, among others, the special rapporteur on the independence of judges and lawyers, as well as the chair of the working group on arbitrary detention in charge of communications. Our second webinar focused on treaty bodies with contributions from a current member of the Human Rights Committee and a representative of the OHCHR Secretariat, highlighting in particular their capacity to respond to urgent situations through interim measures. And today's discussion turned to another key pillar of the UN human rights system, the Human Rights Council complaint procedure. I am especially pleased to convene this conversation at a critical moment, as 2026 is the year in which the UN General Assembly will review the mandate of the Human Rights Council. At some point, nearly every civil society organization has considered submitting a complaint under these mechanisms, yet many hesitate. Some have concerns about politicization of the mechanism. Some have uncertainty around admissibility criteria. Some have questions regarding confidentiality, or some have perceptions of a low rate of success. So these are precisely the issues we hope to discuss today. But beyond these particular considerations, we must also confront a broader and more fundamental question. Is this mechanism still fit for purpose? And if not, what reforms are needed to ensure it remains an effective tool for the protection of human rights? And of course, when we speak of the protection of human rights, particularly in situations of gross and systematic violations, it is impossible not to think of the Gambia, a country that has played a pioneering role in standing up for victims of such violations. As you are well aware, its initiative in bringing the case of genocide before the International Court of Justice has significantly shaped human rights litigation worldwide, later followed, for example, by South Africa genocide case. It is therefore a great privilege to have with us today His Excellency Professor Ka, Ambassador of the Gambia to Switzerland and the UN, and a former member of the Working Group on Situations, where he served in 2024 and 2025. Those who have had the opportunity to know His Excellency acknowledges his remarkable combination of academic excellence and diplomatic experience. Despite his many commitments, His Excellency has kindly agreed to share his insights with us today. Following his remarks, the discussion will continue under the moderation of Dr. Kato Informica. Your Excellency, thank you once again for joining us today, and I now invite you to address the panel. Thank you.
You're mute, Your Excellency.
Yeah, can you hear me now? Yeah, a very good afternoon, and thank you so much for your very kind words and for the introductory remarks. As I indicated, I will have to jump out shortly for another meeting, so I will start with my opening remarks, and perhaps the moderator can go straight to her questions, and then I can jump out, and hopefully I can come back and join you if time permits. Is that okay? Yes, so thank you for this very timely and important webinar. And I will go straight to the question posed, which is still fit for purpose. It's not merely rhetorical. It is a genuine and urgent institutional interrogation, and one that I am glad we are undertaking before and not after the 2026 UNGA review. The Human Rights Council complaint procedure stands as the only universal complaint mechanism covering all human rights and fundamental freedoms for all United Nations member states, regardless of treaty ratification. That is a remarkable and irreplaceable feature of the international human rights architecture. Excellencies and delegates, having served as a member of the Working Group on Situations, I have witnessed from the inside both the quiet utility of this procedure and its very real limitations. The confidentiality that enables state cooperation but can also obscure accountability. The threshold of consistent patterns of gross violations that protects the procedure's integrity, but which can leave individual victims without a clear avenue for redress. As we approach the 2026 review, in my humble view, the central question is not whether the procedure should exist. Actually, I would say it must, but whether it remains calibrated to the demands of a fast-moving, increasingly fragmented global human rights landscape. And we don't have to look very far today to see this escalation all over the globe. Whether it is in Africa, whether it is in the Middle East, whether it is in Europe, it's all over the place, and whether it is in Asia. So today's discussion, in my view, aims to eliminate precisely that. And I will stop there to quickly jump into the question before they come and grab me here. Madam Moderator, thank you so much.
Thank you so much, Your Excellency. It's a very interesting, short. I think for everybody, there are lots of questions that raised what you have mentioned very elegantly. I would like to ask, do you think that with the kind of a review that is in process, we will have a better mechanism, a complaint procedure in place, or this is something that depends on many factors that's also taking place nowadays that we see everywhere in the world, the politics that's going on?
Well, I would say it depends on many factors. The politics that is going on in the world is uncertain and changes by the hour. So it is important for us to understand that the division of labor within the mechanism, you have the working group on communication, which actually is the primary filter, and it applies the admissibility criteria, assesses the merits, and determines whether communications, individually or in combination, appear to reveal a consistent pattern of gross and reliable attested violations. That is not changing. By the time a file reaches to the working group on situation, which I served twice, it has already survived the admissibility and merits assessment. So the work of the working group in communication is very important regardless of the politics of the day. So when the file lands to the working group on situations, the working group in situation is therefore operating at a second and distinct level of evaluation. So it is not a litigating admissibility. And if you recall under resolution 5/1, the working group on situation may decline to refer a communication to the Human Rights Council on the following substantive grounds. One, the communications, even when considered cumulatively, do not rise to the level of a consistent pattern of gross and reliable attested violations. The foundational threshold of the entire procedure. So a clutter of isolated or insufficiently corroborated incidents will not meet this bar. And sometimes this is a frustration of the communication group. The state's response, that's the second point, the state's response provided within the 3 months window adequately addresses or contextualizes the allegations to the working group on situation satisfaction. So the working group on situation have to be satisfied, reducing the urgency or basis for referral. So the working group on situation may determine that the situation has been remediated, that the pattern has been discontinued or meaningfully addressed through state action. So the working group in situation may also decide to keep a case under review at its next session rather than proceeding to referral effectively, a deferral pending further information rather than a dismissal. So critically, all working group situation decisions must be duly justified and indicate why consideration has been discontinued or what action is recommended. Decisions to discontinue normally is taken by consensus, if not by a simple majority. So the requirement for justification is an important accountability safeguard within an otherwise closed process. So from my own experience, let me close by that. From my own experience serving on the working group on situation, the most common reason for non-referral was insufficiency of the evidentiary record. Situations where the communications, while individually troubling, could not be assembled into a picture of systemic, sustained, and serious violation meetings, the legal threshold. So this is both the strength and the limitation of the procedure, regardless of the escalations and the politics of the day. And if you look at it, I think it was only last year when, over the many years, the working group situation was able to advance a case successfully to the Human Rights Council. I hope that makes sense to you.
Thank you very much, Your Excellency. I will hope that you will come back again and we continue, because there are many questions that I think me and other participants will have, but I know that you have other commitments, so please, if you would like to leave, please feel free. Otherwise,
Yeah, I will try to come back as soon as we wrap up, hopefully before you close, so that we can continue on the questions.
it will be our pleasure. Thank you.
Thank you, and my apologies once again. Thank you so much for the opportunity to share some humble thoughts. Thank you so much.
Thank you.
Thank you. Bye-bye.
Thank you. It was really a privilege to have Ambassador here with us. I think all of you agree with me that it was very concise, but every word I think needed lots of thinking about what does it mean, where it wants to go. So again, if everybody allow, I would say hello to everybody. And warm welcome to all of you, dear participants and distinguished experts that have joined us today. It's a real privilege, and I think one of the very important topic really at the best time that we want to address with the best and the most qualified experts that we have in the field. As you could see, Ambassador Kya, and that we hope that he would come back. Just before starting the discussion, I would like to briefly talk about some practical details because I'm moderating this discussion, so I have to talk about these kind of details as well. So before starting the discussion, I will very briefly introduce each panelist. Now we will have 3 panelists, and we hope that Ambassador Kya will come back to us. These panelists are very famous. They don't need at all introduction, but I will do it as a matter of protocol. And for the kind of, as you have heard from the beginning, this session is recorded. And after the session, it will be made public and available online, so you can listen to this later as well. For the panelists, when they finish their presentation, we will continue a moderated question and answer. I will pose a few questions to each of the panelists, and then the floor will be open for questions from all the participants. Feel free to share your question in the chat box at any time, even while the panelists are speaking, and I will do my best to manage the time so that we can address all of them or as many as possible. So with this and without further delay, I would like to open the panel by inviting Professor Elvira Dominigue-Rodendo, professor at law at Kingston University. She has an extensive and very impressive academic background, holding both full-time and visiting positions at many different universities, including, and I just name a very few, Middlesex University, the University of Ulster in UK, the Irish Centre for Human Rights, and Universidad Carlos III of Madrid, if I'm not pronouncing it wrongly, and the list is long. In addition to her very strong academic background, she has also first-hand experience working with different parts of the UN human rights system, including, but not limited to, a consultant to the Special Rapporteur on Torture at the OHCHR. She has conducted extensive research on public international law, human rights, minority rights, and the UN system. But what I want to emphasize and what really distinguishes her work is that her work is a mix of a transnational and interdisciplinary perspective on the subject, trying to advance the understanding of human rights system and cooperation between the states and different actors from international law globally, which is, you agree with me, is something we really need today. Today, Elvira will address the main pillars of the complaint procedure, and one of the topics that Ambassador has mentioned somehow, the criteria of admitting a communication. So Elvira, thank you again for being with us. The floor is yours.
Thank you very much for this very, very kind introduction. Greatly appreciated. And also I want to thank you. I want to thank the Mr. Forat as the director and the International Association for Human Rights Advocacy in Geneva in general for putting together this panel, which is, I cannot tell you how exceptional in its composition it is. I have followed these procedures. I don't like to say it, it reveals my age now, but 25 plus years. And it is the first time I see an ambassador who has been from within the process speaking about it, which is remarkable. And I guess, I hope also again pioneering a new trend among states that they can see it is possible to speak, to explain, to communicate with civil society, and to still safeguard the confidentiality of the procedure itself. So I will take it from where he left it, this mysterious threshold of a gross pattern of reliably attested human rights violations that seem to be the threshold the NGO civil society victims need to meet to ensure that their situation that they are trying to bring to the council will be dealt with. All this within a context of total confidentiality, right? And I guess it's important to highlight where this threshold comes from. And this threshold is the threshold that the Human Rights Council, before the Commission on Human Rights, considered necessary for states to override the jurisdiction of states, to override that states need to consent for violations of human rights to come to their attention, right? So this, in origin in 1970, the idea was the United Nations, Article 2.7 of the Charter, cannot interfere in the domestic affairs of states. Therefore, if we don't reach that threshold, and that was already a big breakthrough, that they could do it if the threshold was reached, and it was linked to apartheid. So states thought, if we are into a situation as bad as apartheid, then we cannot keep respecting sovereignty. And this is where it comes from, but it has never been defined. We know very little on how it is understood, but it is good to have others, and I guess the ambassador's contribution is important on how they see it clearly. It seems that the idea that you need a pattern means that you need a number of violations that happen over time and that they are serious enough. As anything that's confidential, this has not been confidential enough not to have any information from different sources, but also because one of the outcomes of the procedure itself, and others will speak about it, is to publish both the documents that have been produced by others and to declassify the information, but also to appoint other experts, and this can become public. And we know that by serious violations, we have the usual, okay, the summary executed and derogable, the non-derogable rights that are the most obvious ones: torture, disappearances, summary executions. But we also know there are others, from peaceful assembly, freedom of association, and even what is considered normally economic, social, and cultural rights. So we know that the rights of trade unions, of minorities have been addressed in relation to Iraq. We know that some special experts that have been appointed, for instance, in Eritrea, they looked at the right to food, the right to health. So we know from information that is available that all the rights can be in the mix. One of the main issues, and I don't want to take much time, I don't know how much time, I didn't think of it on the start. Can you tell me how many more minutes? Just
I have still 7 minutes.
Perfect. So we know that a wide range of rights can be addressed. One of the issues that also are linked with what the ambassador was saying is the lack, is it fit for purpose? And I think one of the main problems is this threshold means that if you are under a pattern of systematic violations of human rights, possibly, most unlikely, and there is case law about this, the internal procedures are unfit for purpose. Okay, so if you have a systematic gross violation, a pattern of violation of human rights, it means that you cannot access the internal process. However, it is an admissibility criteria. Two things: that you're a victim, and two, that you have exhausted domestic remedies. In my opinion, this exhaustion of domestic remedies should completely disappear. It makes absolutely no sense. This procedure can, if it is useful, which we can only believe from people who work inside, right? And from the very little outcomes we have outside, it needs the victims to engage with it. Because again, from the data we know, 90% of the complaint, of the data that this is known through this process comes from civil society. Civil society has to engage with it, needs to prove that the victims are engaged. And I believe this is an important requirement. You don't want victims who don't know their names are going to be there to discover because of reprisals, right? Particularly because there's no satisfaction for them at the end of this. So I do believe the requirement of being a victim is important, even if it's burdensome. Okay? But you expect the NGOs to nourish the system without having any information, without expecting any reparation for the victims they are defending. And it doesn't make any sense to me, because also I know, even from a practical perspective, civil society also have to demonstrate impact to their funders and everything. So this is like they have to put the work in, they have to prove this exhaustion of domestic remedies that is a huge threshold in a situation by definition where the process is inefficient. And then you will not get any reparation for your victims. And something here has to change, because otherwise it has no future. And I also want to highlight that during many years, it seems from 2014 actually to 2025, when we know that Kyrgyzstan has been is under investigation, but for 11 years we had nobody there under investigation. And it seems like, well, so what is this about? However, it is important to acknowledge that I believe, perhaps, I again cannot prove this, it might be linked to the fact that this way of acting for gross patterns of violations of human rights has been adopted by treaty bodies. So I do not think so much this is a proof that the system doesn't work, that this procedure doesn't work, as much as it has been so successful. States like it so much that now we have, in addition to the Committee Against Torture and the Committee on the Elimination of Discrimination Against Women, the Committee on the Economic, Social, and Cultural Rights, the Committee on the Rights of the Child, and the Committee on the Rights of the Persons with Disabilities. They all have adopted a process that is very, very similar to the complaint procedure for gross and systematic violations of human rights. And I do believe through their own work too, it's going to be easier to understand what do we mean by gross and systematic violations of human rights. And furthermore, the Commission on the Status of Women have had since the 50s a process that is confidential, nobody speaks about, but it's again about individual communications that show a pattern of gross violations of human rights. So I do believe, and all of them on the committees, by the way, have huge rate of acceptance. So almost all the states that are parties to the treaties are also parties to these confidential procedures, which again suggest that the states like it. And I mean, if states like it, we want process that the states like, right? I mean, obviously we also want the process that are transparent and public, because, yeah, for obvious reasons. But in addition, it looks like states engage with this, and therefore there's a value on it, and I'm going to leave it here. Thank you again very, very much for this, for inviting me. I feel honored to be on this panel today.
Thank you very much for this interesting discussion, Elvira. It was very thought-provoking. I noted a lot. I think many people noted the same, and I'm still thinking about what you mentioned, what you finished your discussion about, that the state seems like it, and I'm trying to link it to what Mr. Ambassador has mentioned that the process obscured the accountability at the same time with the cooperation. So how these two interplay with each other, and whether this makes the system to be liked by a state, or I think it's a very interesting discussion to that help us to continue our discussion with our second panelist, who will address what is called the Human Rights Council closed meetings. So, in other words, what happens when the communication passes the two working group on communication and working group on situation, and is referred to the council. As you heard, the review of such communication by the council is in principle confidential. So, apart from the author of the communication and the state involved and the member state, very little knowledge about that is available for other people to understand. And so we actually don't know how decisions are made regarding the discontinuation. We heard Mr. Ambassador about some of the elements. But to know more, how an independent expert may be appointed, or other modalities that will be decided, or the basis of the modalities about the cooperation of a state. So to address this subject, we have the privilege of having with us one of the best experts in the field, really someone who is part of the architecture of the system, Dr. Erik Tistone. He was the last secretary of the Commission on Human Rights, and for those who are as old as me to remember that time, and the first secretary of the Human Rights Council. As such, he was really directly involved in the negotiation that led to the establishment of the council. And he later became the key interface between the OHCHR and the council in all negotiation taking place during the session and between the sessions. Erik has served as chief of the Human Rights Council branch at the OHCHR until December 2023. And since joining the UN, he has also served in very different roles, including the Secretary of Treaty Bodies, External Relation Officers, and Chief of Staff of High Commissioner, just to give you a review of how extensive his knowledge is. And among his many writings on this intergovernmental machinery of human rights, he's the author of a very important book, UN Human Rights Council, A Practical Anatomy, which I say is really the key reference on the subject. And this is not at all the end. He also founded the Late Room Initiative, a space for dialogue with the Geneva Human Rights Platform of the Geneva Academy in 2024, to support the effort to improve the Council's efficiency and to address the geopolitical tension that exists today, which is even worse than before. So, Erik, before inviting you to speak, I would like to once again express our sincere condolences for your loss that you had, and we are especially very grateful that you are with us today. The floor is yours.
Well, thank you very much, Katarina. Thank you for your kind words, and also for your very kind introduction. I think you said a bit too much about myself, but in any case, it's a great honor and pleasure to be with all of you today. It's a fantastic panel. We heard Ambassador Ka, who is really a great expert. He's someone who is so knowledgeable, and his expertise go beyond any limit. Professor Elvira, I mean, I've worked with her. I know her for many years, and she's an expert on so many different fields. And Mark, who is going to speak later, is also an expert on many different fronts. So it's a great panel, and I feel privileged to be there. As a caveat, may I just say that my Wi-Fi is quite unstable today. Swisscom is not working well in my area. Should there be any issue, I would come back to you with my mobile. I'm just saying it in case I disappear from the screen. So to get back to the topic of discussion, what I would say is that the main issue is, of course, confidentiality. Confidentiality means that it's very hard to talk and discuss and converse about these issues, because most of the factual information is not available to the general public. I've worked within the procedure, And I know how it works. I have many, many examples, but I cannot share them with the public due to the normal restrictive rules. We have written an article with Elvira about the confidential procedure, and we hope that this will help shedding lights on this. To take it from where Elvira ended, and of course, after the procedure has taken its own speed with the working group on communications, it gets to the working group on situation, for instance, the one which was led by Ambassador Carr a bit of time ago. And this is where cases are being discussed. Immediately, one footnote which people do not realize, it's not when the procedure gets to the plenary and is eventually referred to in some of the records that these cases, and these are the only cases being discussed. There are quite a number of cases discussed at every single session of the working group on situation by these 5 ambassadors, and they engage into discussion and dialogue with the concerned states. There is very limited discussion with the concerned, the author of the communication, the complaint, but there is ample communication with the country concerned. And that is very important because it means that actually there is a whole array of possible conversations. Ambassador Carr mentioned the various steps which can be taken. A case may be kept pending, it may be dismissed, it may be brought to the upper level. And when it gets to the plenary, there are proposals made by the working group on situation to do a number of issues. All these things are being discussed with the state, and therefore the state is under huge pressure to do something about the case under review. A huge pressure, which is, for instance, and that is something which we may discuss later, to, for instance, extend an invitation to a special rapporteur to visit, to free up detainees, to actually stop certain action which it was doing beforehand, or to avoid enacting a specific sets of legislation. But all this, you cannot get into details and explain it because it's confidential. It gets to the plenary level at one stage. The working group on communication and the working group on situations are normally outside UN80 financial constraints. They are meeting twice per year. And the cases of the, if there are cases brought to the plenary of the council, they go there and they are being discussed there. If there is a concrete case, as was the case of Tajikistan in September, this one we can refer to because it was mentioned in the public records, in the public domain. There is something which is also very important, which you need to understand. There is a whole decorum, which you never see in any other aspect of the work of the council. It is the only moment in the history of the council when the council members sit by themselves. The room is empty except the 47 members. And it's also the only moment when ambassadors, the 47 ambassadors are sitting in the room together. You never see that, except when the head of state is coming. Otherwise, you never see that. And they are in the room with all their assistants, plus the delegation of the concerned country. It's huge for them. It's huge for the 47 members, and it's huge for the country concerned because it's a peer review at its extreme. It's not like the UPR where you have recommendations, whatever. They are really feeling that they are on the spot. They really feel that they are in front of a quasi-judicial body, which it is absolutely not the case. So you have this decorum, you have this pressure, and the states have to respond to questions being posed to them, and they have to justify themselves. They have to say whatever they need to say. And something which Elvira said earlier on is very important. The level of responses by state is accordingly extraordinarily high. They respond not only in a pro forma manner, saying acknowledging receipt of the communications, but they get into substance because they want to prove that they are doing everything okay. We know that they are not doing everything okay. We know that there are human rights violations everywhere, and we know that if cases are before this complaints procedure, it's because there are serious cases of violations. So they have to justify themselves, and they have to show that they are going to rectify whichever issues there are. And when that is done during 2 hours or 1 hour and a half at the council, then the following week, there is a sort of a resolution being discussed, and it's something proposed by the working group on situation, and it is then governed. What is interesting is, of course, that in few cases, these resolutions are made public. For instance, in the case of Eritrea, you would have, that was several years ago, you would see that the case was made public and you would see the resolution and the sort of information contained therein. So it's really exhaustive. And at time, there was at the time of the commission, there were cases where independent experts, special rapporteurs, were appointed within the parameters of this complaints procedure. So confidentiality is helpful in this regard because it draws the stakes very high. Where the problem is of course that confidentiality deprives entirely the complainants and the public at large and the NGOs and the commentators any insight on what is actually happening within the room of the council. I don't know whether you give me, I don't know how much time I do have, by the way.
We still have 3 minutes.
I have 3 minutes. Wonderful,
But you
wonderful.
can go for 5. Sure.
Okay. No, it's okay. So just to say that you do have this very important element of confidentiality. You have this decorum, which I think play a leading role. And you do have all these negotiations, discussion between the working group members, between the room, and also with the concerned country. This is soft diplomacy, but it has an impact on individuals. The problem is, and that's what has been mentioned already now, at the time of the commission, there were quite a number of cases discussed every year. To give you an idea, on average, there were 13 to 14 cases. We can see that when you look into the archives being discussed. For instance, I found it somewhere in preparing for this meeting. In 1995, it was around 14 or 15 cases. Now we are this great gap, which Elvira mentioned, when there was no case at all brought to the plenary. So it's a tremendous difference. But there is a reason why. The reason why is that in between, there was a significant increase in the number of country situations being referred to the council through other means. Country special rapporteur, a country visit of thematic special rapporteur, investigative bodies, the work of the High Commissioner, and so on. For many, it is easier to get to a public mechanism and to put the case there, and you have immediately your response there. The shortcoming of these public procedures and mechanisms is that very often the state doesn't cooperate. Or when the state cooperates, it's very often in a very, very low profile manner. Whereas for the complaints procedure, you have a very high level of engagement, but no publicity about it. So it's a catch-22 situation. And I can give you one, and I finish with this concrete example of the catch-22 situation. It's so unbelievable. You do have a new provision which was introduced when the council was established, which says that in order to come up with something new, the council can also propose or recommend to have technical cooperation. Technical cooperation with the state and the review, and the case concludes there. This is very well, and it was done in 2 or 3 cases. However, you don't have any way at all to see or to control this because no one has the initiative. Once a case has left the working group on situation, it's not the working group on situation anymore. It's not the plenary because the plenary doesn't exist per se. It's not the member state because it's a confidential procedure, and it's not the author because the author doesn't have any idea of what has been decided, of what is the case. So you do have a case where the council decides to have technical cooperation projects, but no one is actually in charge of defining what type of technical cooperation, what type of budget should be given to that, how it should be monitored in terms of implementation, how it should be reviewed, and when that should be done. So that's the typical catch-22 situation, which you have many with the complaints procedure. So I will stop there, and I'm very glad my Wi-Fi held so far.
Thank you very much. Yes, no, perfect. It was not.
Thank you very much. Yes, no, perfect. It was not.
I can, yeah. May I ask you?
May I ask you?
Perfect. Thank you very much. I think.
Perfect. Thank you very much. I think.
Do you hear my echo?
Do you hear my echo?
I think, Mark, you have to. If I yes, thank you. Thank you very much. Very interesting. I think what you have mentioned about non-awareness or the kind of or what you talked about the victims or the author of the communication is a very good kind of a bridge to reach us to our third and the final panelist that will talk about exactly this perspective of civil society, NGOs, and the victim in this very important process. So on this subject, we have again a very strong person, Dr. Mark Lemon, Executive Director of the Universal Rights Group. Mark is very well known and important figure, not only in the field of human rights, but broadly within the UN system, contributing to very key development on wide range of issues. Just to give you a very short glimpse of his wide expertise beyond Human Rights Council, he negotiated agreement and resolution in context of ECOSOC, WTO, UNCTAD, and even disaster risk reduction. He worked as a diplomat at the Human Rights Council at the time of its establishment in 2006, and participated in negotiation on the institutional building package, the Council midterm review, and a wide range of thematic and country-specific issues. Importantly, he was a lead negotiator on 9 different UN resolutions dealing with issues such as human rights and climate change, human rights and environment, freedom of assembly and association, and third protocol, optional protocol of the CRC. He's now executive director of Universal Rights Group, a think tank focused on international human rights policy with offices in Geneva, New York, Nairobi, and Bogota. He has written extensively on international human rights system, and if you specifically about our topic, if you want to know more about UNGA review process, I really encourage you to read his comments on URGA website. Today, as I mentioned, Mark will speak about the role of civil society and victims in this complaint procedure mechanism. And thank you, Mark, very much for joining us today. I know how busy you are and how difficult it is to find you, but it's much appreciation. The floor is yours.
Thank you, Kasayun. Thank you very much. Can you hear me fine? Yes, good. No, thank you and congratulations, first of all, to you and the organizers. This is a very important, but sadly often neglected subject, the United Nations human rights petition systems, which I've always found strange, actually, because if you think about the history of human rights going back centuries to the time of kings, and the way that people asserted their rights tended to be through petitioning their rulers. And that, of course, continued into parliamentary democracy. And yet we've lost sight of that, I think. We did produced a report, which Elvira contributed to in 2018, which I'll refer to as I speak. I hope it's all still relevant, even though it's a little bit old now. Listening to Elvira and Eric, I think it is, because a lot of what they said is similar to what's in the report. Well, before I do that, I would also like to, because it seems to be the order of the day, express my great admiration for my fellow panelists. They don't need me to say that on here. I hope they know it. 2 real experts in the field, especially on this subject matter. The kind of leading question I was asked was about victims, civil society, and how useful it is. And to start that, I would also try and answer the question that was put at the beginning: is the confidential complaints procedure fit for purpose? Before I say what I think, I will just point out that during the 2011 review of the Human Rights Council and its working methods, which of course was the previous review to the one that supposedly now we are doing via the General Assembly and its 2021 to 2026 review of the Council's status. So thank you for the plug for some of our reports on that. But in 2011, many states, especially Western states and especially Latin American states, said it was not fit for purpose, and in fact drew parallels with the 1503 procedure, which they also said was not fit for purpose. And indeed, I don't know if there are any Mexican diplomats on here, and they may not thank me for this, but some countries, such as Mexico, proposed in 2011 to abolish the confidential complaints procedure in the words that were used at the time. Because this procedure promises things to victims that it is unable to deliver. That was the view. My own view, which comes out in the 2018 report, is that is probably unfair, and it is also misunderstanding, and Eric touched on this a little bit. It's misunderstanding the confidential complaints procedure, the clue being in the first C, confidential. It's different to many of the other protection mechanisms at the Human Rights Council because of that confidentiality. Now, unlike many civil society organizations, I'm actually a fan of that confidentiality in certain circumstances. Why? Well, Eric, I thought, said this brilliantly. It's because with that confidentiality comes a greater engagement, usually on the part of the concerned state, i.e. cooperation with the mechanism, and greater engagement on the part of the members of the Human Rights Council, because this is something where they feel, the ambassadors feel as though they can be bringing their diplomatic expertise, their knowledge of human rights and international relations to the table to try and solve problems. I also think it's unfair with the confidential complaints procedure to say it should be abolished because of the issue that's also been raised by Elvira and Eric. It's difficult to have any data or statistics because it's confidential. So it's difficult to know how many cases are perhaps being resolved without necessarily being passed all the way up to the Human Rights Council. So I think, and again, this is, even though it's a confidential procedure, I, of course, over the years have talked to many ambassadors and deputy ambassadors and others that have been in the confidential complaints procedure. And I have regularly heard from them about that if it's used properly, if members of the working group on situations really engage with the concerned country, that there are success stories out there. There are examples of where situations were resolved, where further human rights abuses were prevented, and therefore it wasn't necessary to pass the case all the way up to the council. That's purely, what I've heard from diplomats. I don't have any hard evidence for that. That being said, there are significant weaknesses with the confidential complaints procedure. And again, because I was asked to, I'll look especially from the perspective of victims and civil society organizations, people who are bringing their complaints. And again, a lot of this is based on the 2018 report. What we found, well, first of all, I should say that we looked at the confidential complaints procedure, but we also, in isolation in this report, but we also looked at it as part of an overall United Nations human rights petition system, which means we also looked at the special procedures, communications, individual complaints procedure, and the treaty bodies petition system, where the treaty bodies has. And we looked at the interconnectedness or lack of interconnectedness between the three. And in that, we were inspired by a report by the Secretary General in the late 1970s, where he also looked at the petition systems as a whole, rather than focusing, for example, just on the 1503 procedure. So across the board, but I would say these challenges or problems were particularly grave in the context of the confidential complaints procedure. We found a number of weaknesses. One is the lack of on-the-ground visibility of the confidential complaints procedure. Many victims, many human rights defenders, civil society actors on the ground were not really aware of this avenue. And that led to a lack of awareness and understanding amongst the general public, especially human rights defenders, civil society, and victims, about how the procedure operates and, most importantly, how to access it. That led to a situation we found that often it was only human rights defenders or victims or civil society organizations that were lucky enough to have good connections with big international NGOs. The most famous or the most active at that time, I don't know if they still are, because after we wrote the 2018 report, Amnesty massively downsized their operations in London, who were the people who were focused on the confidential complaints procedure. But at that time, Amnesty was seemed to be by far the most active, and they were, I would say, an essential conduit to advise victims and human rights defenders on how to access not only this procedure, but also the special procedures communication system and the treaty body communication system. Some other problems we found, this problem of accessibility is compounded by a complicated and often confusing user interface. So if you are a victim, your ability to interact with the confidential complaints procedure. Eric will know all about the next one, but it's even worse today in the context of the crisis of multilateralism and UN80, the severe human and technical, for example, linguistic capacity constraints across a fragmented secretariat. Again, a secretariat divided between the three types of petition system. Inconsistent responsiveness. Again, this is a problem with all three systems. I remember in the context of special procedures, for example, talking to assistants of special procedures who said, look, it's heartbreaking. We get all of these communications, all of these petitions. At that point, they didn't really have a very sophisticated logging system, so they would pile them on the desk. And then when they would have time during a week, they would kind of randomly select some of the petitions to try to respond to. And these assistants, of course, is really played on their mind. It wasn't their fault, absolutely. But of course, that's no way to deal with communications. Perhaps it's better with the confidential complaints procedure and feeding information into the working group on communications. Eric would know more about that. Data management, I talked about, was a real problem. Maybe that's improved. So I just couldn't understand at the time why everything didn't receive, when it comes in, a log number and then being put into a IT system so it could be managed more effectively. Again, this was 2018, so maybe that's changed. And I would say, and there were various others, but I'll stop on the problems because it's important to look forward. But a key thing with the confidential complaints procedure is that it's designed, as we've heard, to identify patterns of human rights violations. That's very difficult, right? When you're relying on individual complaints, or even an organization like Amnesty being able to gather complaints, because individual information from individuals on the ground, you need a lot of that, a lot of complaints, a lot of people saying that there are gross and systematic human rights violations in order to be able to say you have identified a pattern of human rights violations. Linked with that, a kind of big challenge. And again, Elvira and Eric probably know whether this has changed. But when we did the analysis, it wasn't possible for the 3 communications procedures to share data, to share information. So, for example, I could imagine a situation in which the confidential complaints procedure was able to benefit from all of the individual complaints, communications sent to traitor bodies and sent to special procedures. And if it was all on an online IT system, it would make it much easier then as a kind of early warning mechanism to spot emergent patterns of human rights violations, right? Maybe I'm being completely illogical, but it seems logical to me. For example, if the Committee Against Torture is receiving a lot of complaints from a certain country about allegations of torture, you could probably imagine that maybe there's a serious probability of patterns of human rights violations occurring there. So in terms of moving from the challenges to the solutions,
And may I
sorry.
Mark, may I ask you to wrap it up so that we can go to the question and answer in 1 or 2 minutes, if possible?
Yes, no, of course. As Abraham Lincoln said, that he was like a preacher, that he would give shorter sermons, but then he becomes too lazy to stop. So anyway, I am at the end, so I'll just say what I think is the solution. I think it's, as Ambassador Coe said, it is to keep and reinforce and emphasize the importance of the confidential complaints procedure. But I really think, and this isn't going to happen in the context of the 2021 to 2026 review, but it's something we can do at the Human Rights Council anyway. It's to really take a holistic look at the 3 mechanisms together and design a system with a single user interface that it's victim centered. So if you are a victim, it's easy to go onto a single online user interface, say, okay, this is the violation I say I have suffered. It would automatically send that information to the relevant part of the system, whether that's special procedures, treaty bodies, CCP, or all 3. And then that would also allow a greater efficiency in the resources, human resources in the Secretariat, to be able to deal with these hundreds, if not thousands, of communications that are received. But that takes enormous ambition, and I'm not sure at the moment the diplomatic community is ready for that kind of level of ambition. But if there's any on the in the meeting today who disagree with me, I'm happy to be corrected. Thank you.
Thank you. Thank you very much, Mark. I would like to, we have 30 minutes. I would like to ask a few questions from the panelists and also later be able to open. We already received several questions. So I would start first with Elvira. So you talk about the admissibility, and we heard that one of the criteria for dismissing a communication at the beginning is that it's politically motivated. So would you elaborate this? We heard from Ambassador Ka that sometimes it talk about evidentiary. So how is it really processed? This what is the threshold?
I wish I actually really knew. I think Eric, if he can, will be able to answer this better. My understanding from secondary sources on this is that it mainly means that a communication just contests the legitimacy of a government per se, rather than engaging with the violations. This is my understanding of that ground, but I do not know how it operates in practice due to the confidentiality itself. And in the same way that there's some information that escapes, right? The working groups and because we know the NGOs are not, that's important to say too, civil society is not covered by the confidentiality requirement, right? So if you want to, you can submit the information and publish everything you have submitted and say, we have submitted all this to the procedure, It doesn't normally happen, but Amnesty has done it a couple of times. It has published, this is what we submitted. So confidentiality only covers them, not the NGOs themselves. Another thing is whether or not this is strategically a great thing to do. But yeah, I don't know, but I cannot not answer a bit to Mark too. I think the problem is not so much, there's so many layers. I will just take 3 minutes. But I think the problem is not so much on how easy it is for the victims to access, which is a problem. At the same time, I believe this idea that human rights mechanisms, considering their complexity, do not need expertise to be accessed. I mean, we will not think this about architecture or something else, right? I mean, I understand we need to know who to access, but then I think it's become so complex that it's impossible not to rely on some expertise from the civil society, from the office from everybody involved. I do believe that one of the main issues is that is not new, is this idea that they shouldn't duplicate information. That if it goes to the treaty bodies, it shouldn't go to the complaint procedure. And this, I'm afraid, the Office of the High Commissioner has to answer to. I mean, this idea that they completely avoid duplication if they can. And I don't know exactly how it works now, because again, this lack of transparency is not only from states. The Office of the High Commissioner and those who work in the civil society one knows better, but if you want to know exactly how the High Commissioner works in terms of organigram, on how you cannot understand fully why some kinds of rights are neglected or others, unless, or how it has evolved. If you don't see that until, I don't know, well into the 1990s, economic, social, and cultural rights will be on the research branch, and the others will be on the special procedure branch, right? And this was not public. You couldn't know it if you didn't have someone in the inside, which is crazy. I mean, it's just crazy that the Office of the High Commissioner protects even its organigram, because it influences everything. And when I was working there, the 1503 procedure was the Pandora box thing. So if it didn't fit, and I don't know how it works now, but if you do, the office makes the assumption that the experts are better than the states, and that treaties were better than the special procedures. So if you could put it on the treaties, you will put it, otherwise it will go to special procedures, otherwise it will go to 1503. And this makes no sense, because one is for patterns of violations, and the other ones, and the victims themselves didn't know where this was going to end. So I don't know if this has changed with better databases or whatever, but the idea that you cannot duplicate when some mechanisms are being looked at by experts, and another one is about states, and one is for victims, and another one is for patterns of violations, is nonsensical to me. And that's how it worked. And I'm probably, Eric will be the best person to contest this way of working, but this to me is one of this idea that you actually can duplicate when the procedures serve different purpose. And then you can actually have a violation being looked at by a treaty, and at the same time being looked at by states, and it's okay. And I do believe Eric is right that because other mechanisms, all led by experts, have been looking at treaty bodies, at regions or states or territories, this has meant less on the complaint procedure. But if this is true, if you really prefer experts, then you really have to make it disappear. I don't know if I'm explaining myself. You either want both types or not, and you consider them different. But if one is only when nothing else works, it's going to be very complicated. It makes sense.
Other panelists Eric, you want to comment on, please?
So many things to say. So I'm sorry to step in. I think there are several issues to consider there. First of all, if you remember the 1503 communication process, the way it worked, that was something which was built in the 70s or 60s and then implemented in the 70s. It was mostly to be one of the few channels where country issues could be referred to. There were very few thematic special rapporteurs. They didn't exist. They existed in the 70s. And the country matters were Southern Africa, apartheid, there were Israel, and later on Chile, and so on. So you didn't have many avenues to get your cases there. And the communication process in the treaty bodies were in its infancy, and the treaty bodies would not exist for several years. So that was the main conduit. And you could go there and you discuss, and the states were involved. Now it's a complete reversal of everything which we have seen in these, which we saw in these years. Now it's something which it's a residual type of procedure which you use when no other procedure is available. And the human rights, the UN human rights has taken so much importance in today's reality. It's one of the very few components of the UN system, which I suppose the individuals in the world, they believe it, that it is working quite well. And you see it today when there are urgent debates being convened on matters which possibly could be raised elsewhere, but it gets there. Issues are being focused in the council and the special rapporteur and so on, which means that most of whatever happens and gets to the office of the High Commissioner for Human Rights will be directed to something else immediately. Give you an example, no state referred to, but let's say you have an issue about freedom of expression. It reaches the Office of the High Commissioner for Human Rights. It will not get to the complaints procedure. It will get to the Special Rapporteur with an urgent appeal. If you do have something concerning indigenous, they will think very hard about who may be dealing with it. And it's only if they cannot find a proper conduit that it will eventually get to the complaints procedure. The complaints procedure is residual. And since the UN is working in silos, whatever it is, I've worked in the UN, so I can confirm that this is the case, and everyone can confirm this, which means that there is no real communication between all these various layers of the UN system. It means that there is no real type of understanding of what the others are doing. So the doubts about the complaints procedure will be very high among those dealing with treaty bodies, and similarly with complaints, with the communications reaching the special rapporteur. So all this makes it utterly complex, very, very utterly complex. There is a bottleneck. There is all this is very hard. However, the main we should remember that if an issue is not dealt with at the council, because it is really touching a country which no one talks about, which is touching a territory which no one is really concerned about, which is touching some of these cases, the complaints procedure will help shedding lights on it, because that's the only place where you will be discussing it. If you look into the list of cases dealt with by the council in the past decade or so, or in the past 2 decades, you will see that there were many cases which referred to states which would never have been considered in the council at all. Eritrea, no one talked about Eritrea before it reached a complaints procedure. So don't expect that one big case will get to the complaints procedure and blossom there, because there are so many other procedures. However, if there are cases concerning countries or territories or issues, indigenous group, whatever, which no one is talking about, maybe that is the best avenue to go to. I think I've talked too much. Sorry.
Thank you. May I ask Eric another question? Mark, do you want to comment on this, or
Yeah, just two quick points. Very interesting what we've just heard, but on the first point is, yes, I agree with Eric on the historical background, but my point is there that it's simply not good enough in 2026, that it will always be complicated, because the confidential complaints procedures of the complaints procedure of the treaty bodies, it's in the treaties or the optional protocols, special procedures, it's in the mandates. But for the victim, for the user, it shouldn't be complicated. As I said, there should be a single interface called the UN petitions, human rights petitions portal, where people can easily send in their individual complaints, and where that data, as Elvira said, can easily be shared between the different mechanisms. And, in that sense, we've gone backwards because in the late 1970s, as I said, the Secretary General of the UN produced a report on the UN human rights petition systems, and that dealt with all three of the systems together as one. The second point is to understand the value of the confidential complaints procedure, you need to remember one word, and that is prevention. And this is often forgotten at the Human Rights Council because we're very bad at prevention. Eric talked about urgent debates and special sessions and country-specific resolutions. Yes, we do all of that, but they are reactive. That's always reactive. Whereas the confidential complaints procedure plays to the potential strengths of the UN human rights system, which is to prevent further human rights violations and prevent crises from developing. And in that sense, I really think the confidential complaints procedure has played a really important role. And so we should build on that and use it as a central part of a strengthened prevention operational strategy at the Human Rights Council.
Thank you. We are going short of time. I just want to ask the three of you, very short, do you think that the review that is going to take place by General Assembly will have any impact on the complaint procedure? And how would you see that? Will it strengthen it, weaken it? What is your kind of prediction? And then I will go, if you make it short, then I will be able to ask some questions as well from the audience.
Shall I go first since I'm still up? The 2021 to 2026 review has been a great disappointment so far. We've been calling for the Human Rights Council in Geneva since 2019 when we produced the report Vision 2021 to take this seriously and to use it for exactly the kind of review you're talking about. All the different parts of the Council's mandate, how well is it working and what improvements can we bring? But states have just not taken it seriously. So here we are in March 2026 and there's very little opportunity now for a serious reflection on any of the parts of the Council's mandate, including the confidential complaints procedure. And that's Geneva. In New York, I think they don't even probably know what the confidential complaints procedure is, and they don't care, quite frankly. So I expect that review will just end with a simple decision saying the General Assembly decides to keep the status of the Council as it is. Sorry, depressing answer, but there we go.
Thank you. Please, Eric, Elvira.
No, I agree. My response when you asked a question would have been simply a straightforward no, for the reasons which Mark explained. I think, not to be too depressing, I think we can revisit this anytime. There is no reason to be bound by the parameters of a review. At any point in time, a state, a group of states, civil society may come up and say, listen, this doesn't work. You have only had one case in 11 years. It doesn't work. So why don't we change it? What it requires is political will on the part of states. We have heard Ambassador Ka. There are many ambassadors from what the Canadian Prime Minister called the middle powers. These middle powers, when they have time and when the international environment will be different from what it is now, they will have the possibility to get into this and to try to change this. But it won't happen in 2026, not in 2027 either, maybe later.
Can I say something? I don't know, yes or no. Every time they have tried to change this one, they haven't changed it. But I do believe a lot is about lack of knowledge and the fact that it depends largely on NGOs feeding it. And NGOs have to make an assessment if this really worth it. I believe I saw the suggestion by Elodie Tranchet that it would be perhaps an idea to have other mechanisms that they see here there is a pattern. So perhaps you should guys also look at it as a state. And I'm sure if this proposal went through, that will be something perhaps exciting even for the special procedures and for treaty bodies to engage with. But you need them to know about it. When we were working on the article, Eric Tistunet and I, the Office of the High Commissioner removed the link to the complaint procedure. I think because someone who was reviewing the website didn't know it. So, I mean, I think there is the need to know about the process, and then anytime it can be improved. Particularly, we think it can be good for prevention. And again, prevention will mean removing the exhaustion of domestic remedies to be even possible. And I'm going to leave it there.
Thank you. Thank you very much. Very interesting last point. So we have a few questions, several questions raised in the chat box, and I would try to raise them. Some of them I think has been already replied. There is one question or one issue that raised by somehow two persons, Elodie Tranchet and Zobi Mogay. They all talk about the transparency, but at the same time, the kind of impartiality of the system. So while I would read what Elodie Tranchet has written, for example, if when the council is the state presence is so strong, how would ensure that the discussion are impartial and would reflect the perspective of the civil society and the victims when there is no adversarial approach? And also, for example, to the same kind of discussion, Zobi Mughal has mentioned how we can, in the confidentiality, how this makes sure that the strong states, like the one that we know, will be also reviewed in the same way as other states. How this kind of system will be ensured when the transparent confidentiality is in place.
Thank you. Many things to say about all this. To start with the latter, the big states, there was a reference I think on the right-hand side column, the chat box. Yeah, well, if you want to discuss the issues of human rights in one of the P5, possibly the complaints procedure will be very hard to help you out there. It doesn't mean that cases have not been raised there, and I cannot divulge anything. But it's true that it will be very hard given the modus operandi, with 5 ambassadors sitting in the working group on situations. Imagining that you can easily move one of these P5 up to the plenary, that would be a bit tainted with a level of naivety. We are living in a world which is, unfortunately, as we can see every minute when we open our news, it's not a naive word. It's a word which is unfortunately brutal, and therefore it will be very hard. So that's why I also said that probably the best cases to look into this would be the case which are a bit forgotten, which are not referred to in the plenary, which are not referred to maybe by NGOs in the public context of. So these are the and I alluded to the Eritrean case, which was very typically one of these cases which emerged. Now the impartiality. Remember that the working group on communications is composed of experts, but the working group on situation is composed of ambassadors. They are not lawyers. They are not legal experts. And they are not expected to be legal experts because they are not looking into these cases. That's a mistake not to be made. They're not looking into these cases as the expert of the Human Rights Committee or Committee Against Torture or whatever would look into these cases. They don't do that. They look and they try to see, is there a pattern? And that's what they are supposed to do. And to do that, you don't need to be a lawyer. You need to be able to read the documentation you get. You need to be able to look into the special rapporteur's thematic ones report and so on, and you get to your own conclusions and then start the usual procedural modus operandi where you do have 5 regions being represented in a group. They talk to one another. They talk to the concerned country. What would be very, very important is the level of engagement of the concerned country. If the country is not responding to you or only with very, very general thing, there is a chance that it gets up to the plenary. If the country is engaging constructively and positively, then there is a high chance that it will never reach the upper stage. And that's unfortunately where the confidentiality is the worst advocate for the council, because you're never aware of the good things which are happening. That's the point. You're only aware at the very last moment. when you see that states have reacted at the last moment and they come up with a big delegation and they are keep dismissed or keep under review and then dismissed at a later stage. So that is what is very sad. And we cannot say anything more. I've witnessed several cases where I saw changes for victims, but you cannot mention them because confidentiality. So if one thing has to be changed is the confidentiality, not in the sense of saying it should be a public procedure, but saying that afterwards, when a case has been closed, there should be some release of information, and not 10 years after, as happened in the case of Brazil or Argentina, but really a few months later, you should be able to access the file and not, an eternity later. And again, I've talked too much. I'm so sorry.
Please, Mark.
Yeah, no, first of all, just say this is a super interesting discussion. So again, many thanks to the organizers. Actually, this should be a bigger discussion in International Geneva amongst the many other important parts of the Human Rights Council's work and mandate reviewing. But anyway, it's not. So this is a great space, but we should continue the discussion. The two questions, interestingly, are connected. So the first is about how if there isn't transparency, if there isn't involvement of NGOs, can we really say that due process is being followed, etc.? Again, I think it's important to understand, this is what I think anyway, the real value of the confidential complaints procedure. I agree it's good when very occasionally countries that don't cooperate, that is passed to the plenary. But I think the real value is in the preventative function of the working group on situations. As Eric said, these ambassadors are not lawyers. What they are diplomats. They're diplomats. And so they aren't very good probably at judging a case, but they are very good, or should be very good, engaging with the concerned country in talking, in trying to resolve, prevent further violations, and prevent patterns of violations turning into a crisis and a conflict. It's difficult to know about that because of the confidentiality thing, sure. But that could be dealt with, for example, if just data, I mean, if we go back to what I said about having a single interface, so, all of these complaints are coming in, all these communications, they're being assigned log numbers so that you can actually, without necessarily knowing the names of the people involved or the countries involved, you can at least track what is happening with data. And I say it was linked with the second question about let's just say it, the United States or countries like that. I really think that confidential or that preventative function means that it's more likely that the US could be, to some degree, be brought to book by the confidential complaints procedure than, well, not brought to book, but at least a conversation with them about patterns of human rights violations going on in the US or going on in any of the other P5 because of that confidentiality. Because you can imagine if lots of communications are received by people in the US saying, look, there are patterns of human rights violations suffered by people of African descent that don't have access to the right to water and sanitation, access to education, access to health, then it's, maybe I'm naive, but it's possible because the independent experts in the working group on communications could pass all of that to the working group on situations, and then the ambassadors in the working group on situations could engage the US delegation if they're still around in at least a conversation, and that in itself has a positive impact, even if we don't know about it. The other problem with prevention, of course, is if you prevent something, then it's impossible to measure because it hasn't happened. Thanks.
Thank you. And Elvira, do you want to say final words before the... No?
No, I think I'm fine. I don't want you to run out of time, I think.
No, it's thank you very much. We just have, I think, 2 minutes and we finished on time. But you agree with me that there are many things to be discussed. And I think we follow the advice of Mark. I think this discussion should be continued. There are many things to be explored and discussed, and we could see the potential of discussion of all different aspects of human rights complaint procedure. I would like to thank all of you. Please upload our panelists. It was great. I just enjoyed. I think you did as well. And also the organizer of this the webinar, International Association for Human Rights Advocacy. I would look forward for the continuation of this topic and wishing all of you and the panelists success in this endeavor in these such difficult days and that we are witnessing. Thank you again, and hope see you again.
Thank you also for the sharing. Thank you very much.
Thank you.
Thank you.
Thank you very much. Goodbye.
Bye.